All right, good morning. Welcome to the 294th District Court. My name is Judge Chris Martin. I appreciate you being patient with the court as we move about location to location. This courtroom became available, and so I thought you might appreciate the larger area. So I moved that yesterday. Sorry if it's an inconvenience for you. This court is doing its best in finding temporary locations for both settings such as this, jury selections, trials. We're moving all about the county, so appreciate your patience and understanding on that. Court is going to call this morning's docket. When I call your name, please say present or here and raise your hand so I can mark you as present. Giovanni Chavez Rosales. Christian Grindel. Jordan Patillo. Jordan Dion Owens Patillo. Thank you, Mr. Abraham. Andrea Pullings. Is Ms. Pullings out there? Aaron Ham. Robert Stanley. Kalen Cheatham. Kalen David Cheatham. Okay. We'll see if he shows. Elkin Martinez, CR 22-307 and 277, waiver of arraignment filed, approved, pretrial set January 24th, 9 a.m. Quincy Hankins. Derek Bolden. Derek Cordell Bolden.
Judge, he just came over and gave you.
Thank you. Becky Browning Whitworth.
She's here, Judge.
She's in the hallway, or?
Yes, Judge.
Thank
She's
you.
in a wheelchair.
Oh, thank you. Glenn Christopher.
He's here, Judge.
I saw Mr. Christopher on the way in. Kevin Ehrenfeld. Kevin Max Ehrenfeld.
Judge, I haven't seen him. I believe he may still be in custody.
You think he's custody where? Mr. Manning says he believes that Mr. Ehrenfeld may be in custody in Wood County. Laura Fleming. Dennis Jones. Dennis Ray Jones. Sanaya Jones.
She's here, Judge. Oh, that'll be a plea.
Thank you, sir. John Lejean.
He's here, Judge.
Thank you, sir. Michael Lobb.
Judge, I have not seen Mr. Law. My understanding was he was in custody here in Mason County. He may have bonded out though.
He did get out. Do you know when he got out? He's not in our custody. Soon will be. Benny McFarland.
He's here, Judge.
Miranda Opry.
She's here, Judge.
Trammell Price.
I believe I saw Mr. Price earlier. I haven't spoken to him this morning. That will also be a
Plea. He is. You haven't seen him. You want to go meet with him? He's outside. Stephanie Rios. Stephanie Rios.
Judge, at last docket, she was in Denton County. I believe that she was released, but I have not spoken to her since then.
I would note that she was released on November 3rd. Is that what you think? She was released from Denton or
Yes,
here?
I believe she was released from Denton.
Larry Rudd.
Judge. He was in Dallas County on a parole hold as of beginning of this week. I spoke to his parole officer and she confirmed that he was there. I looked it up, was able to pull it.
Ms. Tabraham, Mr. Manning has indicated that he's spoken to Mr. Rudd's parole officer and has confirmed him in Dallas County custody earlier this week. If we'll get confirmation of that. Michael Sanders.
He's here, Judge. That'll be a plea as well.
Thank you. Lindy Delaney. Megan Bailey. Megan Nicole Bailey. All right, we'll recall that. Lewis Johns. We'll recall both Megan Bailey and Lewis Johns based on the motions for continuance set earlier this week. Justin Hodges. Justin Wayne Hodges. Ms. Tabraham, if Mr. Hodges doesn't appear shortly, will you contact Mr. Stevens and have a note here that he'll be late? And if Mr. Hodges is or doesn't show, then there's no need for Mr. Stevens to waste his time and effort. And perhaps he has information for us about where Mr. Hodges is. Andrea Young. Lana Calder. Seth Atkins. Christopher Watson. Martavius Wilson.
He was here earlier.
You've seen him. Thank you. Marvin Anderson.
Oh, that's gonna be.
Thank you, Mr. White. Monty Austin.
Here, that's gonna be a plea as well.
Thanks, sir. Gustavo Castillo. David Dawson. Cottrell Hickerson. Lanaria Miles. Wendy Price. Preston Schwartz. Thanks, sir. Please. Okay. All right. Is there anyone who's present in the courtroom and you have not heard your name called? Okay. Everybody's okay. Great. Thank you. All right, counsel, do we have anyone that's ready? All right, Mr. Manning.
Recall Miss Becky Browning.
Miss Browning. And I'll tell you what, yeah, let's bring her this way. And then that way she doesn't have to try to maneuver the narrow aisle there. Deputy McLeish was already ahead of the game on this. Knew what we were thinking.
We're here for a minute today. I've gone over the indictment with my client as well as the discovery by this point in time. She understands charge against her name and spelled correctly. She understands the range of punishment and please not guilty this time. But
All right, cause number CR 22-318, State versus Becky Browning Whitworth. Court will find that Miss Browning Whitworth has waived the formal requirements of arraignment. The court will enter her plea of not guilty into the record, and the court will set Miss Browning Whitworth for pretrial hearing. Mr. Manning, I have January 5th, unless you think that's too soon. If you think it's too soon, we can bump that out.
Judge, I requested, I kind of feel like I have an incomplete file. So at the moment, all the office reports I've gone through does not support the indictment. And so before filing the motion to quash, I'd like to give the liaison some time to get remainder of those documentations to so we can review those and make sure we have everything. we need to-
February 9th. All right, Miss Browning Whitworth, the court will see you again on Thursday, February 9th. Okay, stay in contact with Mr. Manning and your pretrial release officer.
Ready on this one.
Ms. Fleming. CR 21-261, State versus Laura Joy Fleming.
Judge, this was a case I was given, recently. Taken over for motion of substitute, and we reviewed the case file, we provided information to the DA's office. We weren't able to have the resolution, so we requested she look back on the jurisdiction.
All right, court will place Ms. Fleming on the jury selection docket. We'll begin that on Monday, January 9th. So Ms. Fleming, you've been on the jury selection docket before. You know the routine, right?
Yes.
You know where to report. So we'll start that back on Monday, January 9th.
Will that be at 8:30 or no?
8:30 is fine. Yeah, January 9th.
Judge, ready on Mr.
Glenn Christopher, CR 22-206. Set for pretrial.
Yes, Judge, we've received a new plea offer, that is contingent on, some other pieces. I would request that you set from three, just a little bit further out.
Further out than when?
If we can do the February date, that'd be fine.
Any objection from the state?
No.
All right, court will set Mr. Christopher then February 9th. For plea. You're welcome, sir.
Judge, that's the thing as well. If you want to talk to him. I did have one question. Housekeeping, I have two things I wanted to discuss with you today, would you like those to be done? Now, or like release them and have them go to the jail.
So I presume that the agreement's going to require jail time,
Both of them, yes.
both of them. Is there any, are we short-staffed? We can transport, we'll take them into custody today.
This one.
Yes, I'm sorry, this one. Mr. Bingham, you ready?
Judge, how are you?
Doing great, sir. How are you?
I have two, I think, real quick.
Any order?
Aaron Ham.
Aaron Ham, CR 22-216.
Governor, in that case, they had the motion to dismiss. We visited at length with the victim yesterday, and based on what she told us, there's insufficient evidence to participate for conditions.
No objection from the defense.
There's no objection to that at all.
All right. Based on the state's motion to dismiss, court hereby grants the dismissal and signs the order of dismissal. Mr. Ham, you're free to go. Robert Stanley, CR 22-294. Good, Mr. Bingham.
Judge, this is a case that we've been talking to, it involves for civil litigation, documents we're trying to get, it involves experts, and I appreciate the DA's offices, we've been talking length about it. I think it's a case. I'm hopeful that will get resolved in the future. If not, if we're moving a trial case, it won't be I would not anticipate a plea, but I'm hoping we have a little more time to get the case resolved.
I agree with that, Your Honor. Mr. Bingham has made some representations to me that in the civil litigation, some facts came out that would be significantly mitigating for Mr. Quinlan. Mr. Bingham is trying to gather those to provide them to us so that we can make a decision about where this case goes from there.
It's hard to judge. There's a lot of lawyers involved, so I'm trying to find out where. I know what I'm looking for, but I need to find out if it exists. I've got that information today. So I'm going to be gathering that information. There's multiple lawyers involved. And this is a little bit different in the case. So I think it'll make a difference to this story. And I have told her this is something I want to get to it. So
Well, I showed today's pre-trial. Are there any?
there's not. It's
Okay.
the standing order. The court pointed that out to me last time I was here. I now read it. And I think it covers everything. There's nothing that we need to have, but they've been very good about getting us information and giving us what they have. So there's nothing.
All right, if there's no contested pretrial motions or issues before the court, then the court would set this for docket call. Are you requesting more than 30 days or so?
Well, I am, Judge, I know January, I mean, what Kerrville or Travis County wanted to. What's,
Yes,
the best day you use?
and I have January 24th available.
24th.
Okay. All right, Mr. Stanley. Court's going to set you for docket call on January 24th. That'll be at 9 a.m. Location to be announced.
We'll let you know. Judge, that's all. There is, I guess, on the motions, one thing, if we get to that point, we do have experts that will provide. I think we already have provided the name of some of those to the state. I'm sure they would, other than that, we don't have to.
And I think that's part of the court standing orders also. Okay.
That's the only thing I think.
All right, Mr. Stanley, once you sign the notice of appearance and get your yellow copy, you're free to go. Thank you, Mr. Bingham. Mr. Damon, are you ready?
Yes, sir. All right.
Did Mr. Cheatham appear?
Yeah.
All right, Mr. Cheatham. CR 22-205 State versus Kalen David Cheatham set for pretrial. Go ahead, sir.
We don't have any pretrial issues today. I spoke with the state. I have two big options for Mr. Chief to consider. There were 3 discs that I picked up that did not blank. I turned it back over to the DA's office today. They can make another copy of that. The beauty discovery, it's not critical. I have a full understanding of what the case is. But for all the diligence, I'd like to go get those made. We just request another docket call for him to consider these options. He also has the Dallas case to find. We would like to have them work out and watch.
Any objection?
If we could set up for a docket call and we would not object to Mr. Diamond filing untimely pretrial on that basis. That's one of the first.
January 24th.
Yes, I'm great at that.
All right, court sets Mr. Cheatham for docket call on January 24th. That'll be at 9 a.m. January 24th, 9 a.m. Yeah, just, yeah, you can lay them right there.
This one's done. We have a motion to withdraw on call, let's go ahead and close that today.
Page 7.
All right, so Mr. Wright, have I already signed an order granting your substitution?
No, you didn't, Your Honor. I was under the impression that, withdrawn, that was look at it. So I just thought a letter of recommendation.
Okay, so I've slept since then, so I can't remember. So you're telling me, Mr. White, that you are here to represent Christopher Watson and have no objections to Mr. Diamond being withdrawn by the court? Thank you, Mr. Diamond. You're free to go. And if I haven't signed an order, I will find that order and I'll get that signed. All right. Thank you, Mr. White. Are you ready to announce on Mr. Watson, or do you want to talk with him?
I'd like to be able to talk with him, but Your Honor, I haven't received any discovery yet because I recently just filed a letter of representation. I'm going to be needing to reset the.
Well, let's go ahead and bring him up so he'll be a part of this hearing. This is cause number CR 22-198, State versus Christopher Storm Watson, set for pretrial. Court recognizes Mr. White as new counsel for Mr. Watson. The court will reset today's pretrial hearing for an additional pretrial to give Mr. White an opportunity to get the discovery from the state. Are you available on January 24th or January 5th, Mr. White?
I think January 24th would be best. I understand that this discovery might be right at the moment.
All right, court sets Mr. Watson for pretrial January 24th at 9 a.m. Mr. Watson, once you sign and get the yellow copy, you're free to go. That's what I mean, it's correct. Let's see there on. Okay. Awesome. Here, you want to keep those? That way, if you need them. Good morning, sir.
Brent was here on.
Ms. Young. CR 22-121. State versus Andrea Nicole Young.
We have filed a motion to suppress murders.
All right, my next evidentiary docket, Mr. Thorson, will be on January 26th. Do you have any scheduling issues on that day? Yeah, please do. Please do. Okay, court sets Ms. Young for evidentiary hearing on January 26th. That'll be at 9 a.m. And as you heard me say earlier, Mr. Thorson, I'm not sure where we'll be. We may be back upstairs. We may be in one of these others, but my coordinator will email out prior to the docket. So if you'll watch your email, you'll know.
All
right. Thanks, sir. Ms. Young, once you sign and get the yellow copy, you're free to go. Mr. Murray Leader, are you ready?
Good morning, Judge. Yes, I am.
Lindy Delaney, CR 2399, CR 21150.
Staying right now.
All right, I believe this is on your motion for continuance, Mr. Murlater.
That's correct, Your Honor. I asked for 2 grounds, and it's the first ground was for the live report. Since I made that available to me when I first called this motion on November 22nd, and it has not yet designated an expert witness for that live. The state is agreed on the continuance on that ground. The second ground, Your Honor, follows continuance and objected to the First Baptist Church being a venue for board hour and jury selection for this case, which is currently set for December 5th. And in my motion, I argue that it's a violation of the establishment clause, due process, as well as the right to a public trial with the 6th Amendment. I provided some case law under this ground. The Texas Court of Appeals didn't rule on the establishment clause grounds. They ruled that if it's not open and accessible to the public judge, it shouldn't be permitted. Is there no other alternative, Your Honor?
Well, let's stick to your motion. So do you have reason to believe that the jury selection, well, and let me first clear up any confusion for the record. The trial will be conducted at the Justice of the Peace Precinct 3 courtroom in Wills Point, Texas.
Yeah.
The only venue available to house the jury with sufficient size, with proximity to the courthouse, convenience of restrooms, accessibility, is the venue where it's currently scheduled, which is a building owned by the First Baptist Church, which is not closed to the public. And the proceedings will be live streamed, can be live streamed via YouTube to ensure that the defendant receives an open trial. So at no time will it be a non-public trial, but the trial itself, exclusive of the jury selection process, will be conducted in a municipal building, or a county building rather, in a municipality within Van Zandt County.
So the way the science looks to me, just that the jury selection happened at the First Baptist Church, and then we conduct a trial at another place. That's fine. We go and conduct a trial and I understand the reason for wanting a much larger case for jury selection. However, I still have to object under the establishment clause, Your Honor. In reading the case law on this, in that Lilly versus State case that I cited, the Court of Appeals case actually went into a deep discussion and analysis onto why the establishment clause might be violated if even just a jury selection is held in a religious house of worship. They basically reiterated the reasonable observer test to determine whether or not a reasonable observer would, seeing the case from the outside, would determine whether it is being used to convey a Christian message. And the Court of Appeals in that case did rule that it violated the establishment clause. However, the Court of Appeals did not take up that issue. They just took up the public trial issue. They reversed on that issue. So in order to preserve this, what I would have to do is I would have to, number one, follow this objection today, and then again, I'll have to urge the objection to be a trial. And if the trial is adverse to my client, at least I've preserved the appeal, but I want to make sure that at least preserve that issue here.
Your lab issue, that only pertains to one of the state's cases. What about in the other CR 21-150? Do you have any other ground for continuance other than venue?
No, Your Honor, that one, the state has provided me the discovery on. I do not believe that they're designated in that case, however. That's just the state judge only registered one vehicle case. My understanding was that this license was going to designate or has already designated at recall hearing the second degree felony manufacturing delivery.
But if the court grants your continuance on that, that would move us to the next case in line, which would be that case.
I don't have any grounds for continuance on that other than just objecting to the establishment position.
Right, but I'm saying if the court grants your continuance as to the late disclosure of an expert witness under the court standing order, and the court denied your continuance on the venue ground, arguing the establishment clause, that would bring us to the next case, which would be CR 21-150 that doesn't contain the lab issue. I'm
No,
sa-
it doesn't continue, but I'll call a continuance for that, just for the establishment clause, just to preserve that issue. However, like I said, I don't believe the state is taking a position on that. They're only agreeing to the lab issue. However, Ms. Heisel told me she designated the drug case control, not the state judge. So, but I can be ready on the state jail case. It's just that they've designated the drug case.
Any response from the state?
Your Honor, Mr. Whirliger is correct with regard to the lab issue. Is a complete oversight on our part. That didn't get sent to the discovery board. We weren't made aware that it hadn't been sent until approximately 10 days ago or so. And we sent it immediately when we requested it. We have, however, designated the expert. The expert was designated well before pre-trial. With regard to the issue as to that continuance only applying to the current case and not the other case, the court is correct. And Mr. Murley was correct that we had designated the drug case, however, next in line would be the that case.
All right, the court will take the motion under advisement, and I'll issue a ruling later and notify the parties.
Your Honor, just to be prepared, if the court is going to grant the continuance, does the court have a trial date? But I can ask my client to sign the reset form.
Well, I think she's already noticed to be here on Monday. So if the court grants it between now and then, I will have my staff, I'll put it in the order. I'll put her new appearance date in the order.
Okay. Thank you.
Mr. White, are you ready?
Please, sir.
All right, are you ready on both of them?
Yes.
Martavius Wilson, CR 22-343.
Your Honor, this is,
Is Mr. Wilson here?
maybe sitting outside. Sitting outside. Your Honor, this first pre-trial, I believe we still need a DVD, but I don't think we're going to have need an extremely long reset. I believe we've had some preliminary negotiations that seem very, very good. And I think we'll probably come to a resolution on this case as soon as I get a chance.
Do you have the DVD? What's the issue with the DVD? Is it failure to produce? All right, so I'm trying to counsel everyone to not delay, because it's going to.
That's why I do file a specific motion, which I have filed.
I know, I try to grant counsel the ability to file waivers of arraignment, and then I try to set it out 30 to 45 days to give counsel time to get all the discovery, so you can follow your pretrial motions. I'm going to reset it today, and we're going to add another 30 days to it, and that's going to put us 60 to 75 days out from a waiver of arraignment. So
We can go ahead and put it on down.
no, I don't want to do that. I'm just saying that I'm trying to remind.
It's probably my fault. It's probably my fault.
All right, court's going to reset Mr. Wilson for pretrial, and I think Mr. White, I set you on the 24th for Mr. Watson.
Be good.
All right, court's going to set Mr. Wilson for pretrial on January 24th at 9 a.m. Mr. Wilson, have you signed your pretrial release conditions? Have you met with the pretrial release officer? Okay, sign that, and let's talk about that real quick. Mr. Waddell, are you still meeting with Mr. Wilson?
I'm trying to,
Okay,
I told my plea without seeing.
So, Mr. Wilson, the court has conditions of pretrial release that are assigned to you. Basically, they're conditions of bond, the conditions that you're going to have to comply with in order to maintain your liberty while you're waiting for trial in this case. Okay, these conditions, you're going to get a copy of them. They're going to go over them with you from the pretrial release officer. These conditions are that you're going to have to report to the pretrial release officer. You may be drug tested. You're not allowed to commit any new offenses without there being any violation of those may compromise your bond in this case and may end up with the court revoking it and putting you back in jail. Okay, so make sure you comply with those. Meet with Mr. Waddell, and once you sign and get a copy, then you're free to go. Is that all you have, Mr. White? Seth Atkins, CR 22 1, CR 22 236, and CR 22 368. Let's take Mr. Atkins. Let me ask you. I know, Mr. White, you're not counsel of record for Mr. Atkins on CR 22 368. Is that correct?
That's correct, not as of right
All
now.
right. Mr. Atkins, what's your plan for representation on CR 22 368?
You're gonna have to ask the court for a court appointed attorney. That's fair.
So, Mr. Atkins, you got retained counsel on Mr. White, and you're currently on bail of $100,000.
Another $5,000. It's sacrifice, just have the other 22 weeks. That's not how it works.
Well, if you're requesting a court-appointed attorney, then you're going to need to fill out the paperwork and go through that process again. So
That just goes on that case, right?
it just goes on that case. We're about to take up the other two cases. CR 22-1, CR 22-236. Mr. White set for pretrial.
That's correct, Your Honor. I believe we may have had a duplicate DVD, but I made another request and they have it ready for me this morning to pick up. There may be a situation I can maybe get it worked out. Thanks for having this new case, because I can't see it being resolved without all of them into account.
And those DVDs are ready at the office, guys.
All right, the court's going to set Mr. Atkins for pretrial, an additional pretrial on January 24th at 9 a.m. Court's going to reset arraignment in CR 22-368, same date. And is the new indictment CR 22-368, is that indictment alleged to have occurred during the period of indictment in the other two cases while Mr. Atkins has been on release? What I'm asking is there going to be an allegation that Mr. Atkins has violated his conditions of pretrial release?
Yes, Your Honor.
All right, so of course not been made aware by either the state or the pretrial release department of any arrest of this defendant while he's on conditions of pretrial release. So I'm going to set the CR 22-1 and CR 22-236. And I'd like to inquire about that on the 24th.
What is that new cause number so I can put it down for?
CR 22-368. All right, Mr. Atkins, once you get the yellow copy, you're free to go. Mr. Juan, are you ready?
I am. On this.
All right, this is cause number CR 2121, State versus Quincy Lamar Hankins. And Mr. Head filed a motion for continuance. Mr. Wanda, you're here to argue that.
I am to state file one as well. I'm gonna first taking that up as well this morning. but-
Yes, I'm gonna take up both.
Okay, thank you, Judge. Can I proceed?
Go ahead.
Thank you, Judge. So I filed a motion and I feel like I was clear in my motion. But I want to, on the record, make sure that I'm not attacking the church or Baptist. I'm a founding member of Baptist Church in Tyler. My kids go to Christian school. They left for chapel this morning with the church's audience of one. So again, I'm not attacking the church or Christianity or Muslims or temple or synagogue or anything. But I think the case that is directly on point in my opinion is Lily v. State. It's 337 Southwest 3rd 373. It's a Texas Court of Appeals case in 2011 out of Eastland. And in that case, there were two essential issues: whether or not there was violation of a public right to trial, and whether or not having court proceeding in a prison chapel violated the Establishment Clause of the Constitution and the free exercise clause of the First Amendment. And I'm not going to belabor this too much, but what it was, if you're not familiar with the case, there's an inmate. It's a jail or prison case. He was started assaulting public servants, and they would basically use this chapel as a place to have court. And in his situation, it is a little different than ours because he voluntarily pled guilty. There have been multiple hearings in that location that I don't believe he lodged proper objections to. But basically, the court in that case essentially reasoned that it may for the Supreme Court Van Orden 545 U.S. at 688 that the mere presence of religious symbols alone is not enough to violate the Establishment Clause of the constitutional rights of a person. However, they go on to talk about situations in which it's impermissible. They use a standard, basically a reasonable observer standard, which even for an appellate court is very vague. But specifically, they say Perry County, Kentucky versus ACO of Kentucky, and that's a Supreme Court case, 545 U.S. 844, that it was impermissible to have the Ten Commandments present in the courthouse. And then the county of Allegheny, another Supreme Court case, 492 U.S. 602, the issue with an activity theme that was seen in principle as well. And so that court in Lilly, basically, and I'm going to quote, I'm going to skip through. It says that the display of McCleary and the other cases cited signal a predominantly religious message to a reasonable circle. Using the Christian chapel for courtroom surely does as well. The problem is in this instance that the chapel is unambiguously a Christian worship facility. And they go on to conclude, we conclude the state violated Establishment Clause by conducting the Lilly's court proceedings in the chapel. And so it goes on to basically assess whether or not, because according to the court, subject to constitutional error, whether or not there's harm. I think our situation is a little different because we have objected to it. We're not doing this voluntarily. There wasn't a proper objection made by Lilly's attorneys at the time. And so I actually think there's a legitimate argument that it is subject to structural error. Now, this case did go up to the Court of Criminal Appeals. This case was ultimately reversed and remanded on the open to the public issue because the court in Eastland said, we don't think your rights have been violated. And then the Court of Criminal Appeals said, no, we think they're wrong, reversed and remanded. So they do actually mention that this whole issue was brought up, that they chose not to address it because they didn't have to, because they had a good issue to reverse and remand on. They also mentioned that the appellant had argued the difference between constitutional error and structural error. They were very silent on that though, but I think there's a good argument, honestly, Judge, and respectfully, that if you don't grant our continuance, that it'll be subject to constitutional error and potentially structural error. You know, we all, we go to law school, all of us here that are lawyers. At some point in time, you kind of have this silly idea when you're young, you want to kind of change the world, make it a better place. And lots of times you kind of, regardless of what you do, you go to big law and litigate, fight over money. You do what you and I did, become prosecutors, fight for victims. You get gray hairs, kids, wives. You just kind of get jaded and numb to it all. I'll tell you that I'm actually really excited and proud to argue this, because this issue in this case, they're the reasons that we have law schools, the reasons we got judges, prosecutors, defense attorneys fight for constitutional rights. And that's what I'm doing here today. Because I truly believe it'd be a violation of my client's constitutional rights. We want to try this case, it needs to be tried. I'm just hoping that you're able to find another location, and I understand the issues upstairs. Even if we can start the trial on Tuesday, if we find a gymnasium or Mr. Winter's courtroom, give us a place that's not a worship center to try this case. Thank you.
There was a space available for this court. The First Baptist Church is not my first choice.
I'm sure.
Well, I don't know how you could be sure, because you haven't gone through this process of trying to find a location. I don't believe that we're any longer welcome at the Farm Bureau. The competing venue sites are not available to us. A school is not going to let a criminal trial occur on their facilities. We have no other county building big enough to hold over 100 people. We have no central grand jury room. That's the only venue that's close enough that provides the citizens a close proximity to the courthouse with ample parking, ADA compliance, convenience of HVAC, comfort. It's been my last choice in order to try to keep the guarantee of a right to trial going. So I understand the argument. I don't want you to think, or anyone to think, that I am out trying to put all of our trials into a Baptist church, or any church for that matter, or any place of worship. This court has been left with little to no options. And so I've been struggling with, do I just shut down the court system and not conduct trials and deprive people of their right to a trial? I don't think that's the right thing to do. Or do I try to find the best location that I can and place it there? The trial will not be conducted at the First Baptist Church. It's only jury selection. I know that there was some confusion about the notice that went out. The trial is not being held at the church, nor would I ever ask a jury to sit in a house of worship and pass judgment on someone's behavior or allegations of their behavior. So I understand that your objection is to jury selection there also. The trial is actually going to be held at the Justice of the Peace Precinct 3 courtroom in Wills Point. So it's never been scheduled. A criminal trial, Mr. Hankins or anyone else, has ever been scheduled in the church. So with that said, I understand your argument. Ms. Curry, the state's also filed a motion for continuance. Go ahead.
Yes, Your Honor. Our motion for continuance is based on the medical condition of Trooper Justin Rhodes. There are two witnesses in this case, two troopers. And Trooper Rhodes was dispatched to the border several months ago, I believe 4 months ago, where he contacted some kind of unusual eye infection that is in both eyes, and has been treated by general medical providers, but has not been treated by a specialist ophthalmologist. He now has a specialist ophthalmologist appointment for that Tuesday. He is, we're told it's a very dangerous condition that could have long-term effect on his eyes. He's waited 4 months for this appointment. He is in such a condition that he can't drive, he can't work. Can't do anything right now until this issue is resolved. He could be driven to court and testify. However, it is vital that he go to that eye doctor appointment that month, which was scheduled well before he knew that this case was going to rise to number one on the docket.
So Trooper Rhodes is inactive. He's not working now. He couldn't be available on Wednesday or Thursday or Friday after the appointment. If the court, I think counsel is aware, I've always accommodated both the state and the defense in taking witnesses out of order, delaying trial, moving it to another day. But you're telling me that Trooper Rhodes he's not working right now. He's not acting as a trooper now, and he won't be acting as a trooper next week.
He could physically, he can come and testify, Judge, if he's here in the court, just not Tuesday morning.
Just not Tuesday morning.
Provided that the doctor doesn't put him on bed rest or admit him or do something like that. You just don't know when the doctor's gonna do.
If we obviously, we have no objection, it's like the court position, whatever, if you deny the motion, both motions to, if we need to pick and start another day, whatever we have to do to accommodate the trooper, we will.
Okay. All right. I'll take the motions under advisement and issue a ruling later and notify the parties.
Thank you.
Okay, thank you, John. Is Mr. Hankins free to leave?
Yes, free to go.
So, and now we will be meeting at the First Baptist Church on Monday morning unless the otherwise meeting.
Correct.
Great.
And if there's a new date, I'll put it in the order and provide it to you.
Thank you very much.
Are you ready on Ms. Calder? Lana Calder, CR 22-3, CR 21-322. Set for plea?
May I approach?
Yes. All right, are you Lana Michelle Calder? All right, Ms. Calder, if you'll raise your right hand. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. You can put your hand down. Just make sure you speak up loudly and clearly for me. Ms. Calder, are you a United States citizen who reads, writes, and speaks English? Ms. Calder, have you ever been diagnosed with any type of mental condition? Can you tell me about that?
Bipolar, paranoid schizophrenia, PTSD.
Are you currently on any type of medication or undergoing treatment for those?
Yes, sir.
Do you feel like you have a rational understanding of this case and what's going on in this proceeding today?
Yes, sir.
In this case, you're represented by your attorney, Mr. Justin Weiner. Are you pleased with his representation of you?
Yes, sir.
Do you feel like you've had enough time to talk with him about your case and have all of your legal questions answered?
Yes, sir.
Is there anything about the paperwork that you've read and signed today that you do not understand?
No, sir.
Mr. Weiner, do you believe Ms. Calder to be competent today?
I do not.
And you've explained to her her rights as they pertain to this case and the waivers of those rights that she's giving up today?
Yes, Your Honor.
And you believe that she understands those?
I do. And she previously waived the right to the retrial, but I still am not sure on that as well. I believe she understands all her rights, Judge.
Ms. Calder, it appears that you are charged by indictment with a first-degree felony offense of manufacture or delivery of a controlled substance in penalty group 1 greater than or equal to 4 grams, less than 200 grams. A first-degree felony in the state of Texas carries a range of punishment if convicted and sentenced to not less than 5 years or more than 99 years or life confinement in the prison, and a fine not to exceed $10,000. Do you understand that range of punishment? I see there's a plea agreement in your case that you're asking the court to approve, that you would plead guilty to that charge, and the state's recommendation would be that your punishment be assessed at 10 years confinement in prison, but that sentence be suspended and you be placed on community supervision or probation for a period of 10 years with a $500 fine plus payment of court costs, reimbursement fees, nexus as a condition of your community supervision. And the state would be dismissing CR 21-322, another manufacturer delivery of a controlled substance between 4 grams and 200 grams. Is that your understanding of the plea agreement?
Yes, sir.
And that's what you're asking the court to approve today?
Yes, sir.
All right, Ms. Calder, at this time, I'm going to ask you, how do you plead to manufacture and delivery of a controlled substance in penalty group 1 greater than or equal to 4 grams, but less than 200 grams?
Yes, sir.
Are you pleading guilty to that crime because you are guilty of committing that crime? Has anyone threatened, forced, or pressured you to plead guilty to this offense? Court will accept the defendant's plea of guilt. Mr. Weiner, any objection to the state's stipulation of evidence exhibit 1?
We have previously received, reviewed, and have no objection to state authorization.
All right, states 1 is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Just briefly, Your Honor, on the case that we were taking into consideration, court will remember that was Mr. Norman Answer was a co-defendant, and he was tried and found guilty and sentenced on that charge. Ms. Calder was a passenger in that vehicle. That's why we're taking that. I know the court would have some pause with 2 first-degree felons. She was involved in that in some way, but she was likely not the bad actor in that case.
Thank you. I do appreciate that reminder. I've slept since then, so that's good. Anything further from the defense? Let's take a moment just to review the evidence. All right, the court has reviewed the evidence. The court finds that there is sufficient evidence to convict Ms. Calder of this offense. Court will follow the plea agreement in this case. The court hereby convicts Ms. Lana Michelle Calder of possession of of manufacture or delivery of controlled substance in group 1 greater than or equal to 4 grams, less than 200 grams. The court assesses her sentence today at 10 years confinement in the Texas Department of Criminal Justice. The court will suspend that sentence, place Ms. Calder on community supervision for a period of 10 years. Court orders her to pay a $500 fine, $180 restitution, $290 court cost, $220 in reimbursement fees. And the court dismisses under section 1245 CR 21322. And the court will order that Ms. Calder attend the Nexus program as a condition of her community supervision.
Thank you, Judge. The first record, she worked very hard with disability sources that she is turning herself into the Nexus on Tuesday. Just so provision is aware that where she's going to be at y'all in the program stuff.
All right, Ms. Calder, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. I'm gonna have you come over here with Deputy Everett to be fingerprinted, and then these officers will give you more information about your next step. Oh. Where's this one?
Judge, I've got a bond hearing at 1:30 in Athens, a quick reset. I had a client that got this meeting appearing to get it in. Is your docket really big? Is it big? I can get it out. There's 2 things that hop on Zoom in my office or. I can handle that.
Let's see. You have Dusty Rhodes.
Yes, sir.
Is Mr. Rhodes going to be appearing from Henderson County?
From the Henderson County Jail, soon, yes.
Then yeah, if he's not going to be in our custody, then yeah, just appear via Zoom this afternoon for Mr. Rhodes.
Just to make sure it's okay.
Yeah, just log in when you can. We have plenty of things that we'll be working on, looks like.
Great, thanks, Judge. Excuse.
You may. Mr. Schmidt, are you ready? CR 2123, State versus Lewis, Randall Johns, and I believe this is the state's motion for continuance. Mr. Schmidt, you've indicated to the court that Mr. Johns is not present today. Is that correct?
That's correct, guys. It's set for Monday. I expect that, but I did not.
All right, the court will waive, this being the state's motion for continuance, the court will waive Mr. Johns' appearance today. State's motion.
Thank you, Your Honor. This is a motion judge to file solely because we're having difficulty locating witnesses. In light of that, in discussion with Mr. Schmidt, we understand the predicament that puts us in for trial. We believe we have the case worked out. We know that it's untimely with the courts, but the court will grant a motion for continuance. I believe we'll get notice of this up in the court. We have diligently looked for these witnesses. I mean, they are necessary to the case. And we're just so hard to make it work.
The defendant agree with the state's motion?
Judge, we don't take a position on the state's motion. I think, as opposed to where my job and we are on the trial line and have that question time. Ultimately, I do want a resolution is available. I believe that it's good, assuming that he didn't. So at the court's discretion, we can be ready if necessary, but we always got to resolve a case like this, and then put it in jeopardy on the second.
And Your Honor, if I may, when we realized that the top cases on the court's list may not be going, we set about finding witnesses on some of the cases that were lower down. We had previously also filed a motion with Megan Bailey. We have in fact located those witnesses and will be, and I'm prepared to announce ready on Megan Bailey's case. We just haven't located things. We believe we will be able to, but we haven't done that. Haven't been able to yet.
How long has Mr. Johns been on the trial docket?
Just going back to the case,
So the state hasn't had any contact with the witnesses or is this an assault case?
it is.
And so the complaining witness is not being cooperative with the state?
We haven't tried to have any contact until now, because it hasn't been in our kind of our target area towards the top of the list.
Okay, all right, court will take the motion under advisement and notify the parties of the ruling.
I believe that's all I see.
You have one this afternoon? You have more than one this afternoon, correct? Okay, all right, we'll see you this afternoon. All right, so Jonathan's still here. So nobody on Zoom. Yes, Megan Bailey. Yeah, I think Jeff wanted that to stay set, so.
No one wanted to choose the case. So I just want to.
Right.
We had previously notified the state that we were withdrawing our motion for continuance on Megan Bailey because we have located the witnesses. She informed me that Mr. Sanders, when they left on today's docket, but I haven't seen Mr. Sanders or his client.
Yeah, I think he was gonna be, I think Megan Bailey is here, correct? Yeah, Miss Bailey, okay, yeah. I believe Mr. Sanders said that he was gonna be a little bit late.
I should
Yeah,
say.
he was estimating, yeah, about now.
Okay.
So he could be any minute. All right, so we got Nolan and Jonathan. Okay. So let's see who we have up here.
Straight Jones is here as well.
They showed up. Where was he at? Was he at the other courtroom? Did he say where he was? Did you talk to him? The sanctions. All right, Mr. Patillo, CR 22-193. All right, Mr. Patillo, I believe that I've set you a couple of times to hire an attorney. Where's your attorney? Do I need to? Tell me how much longer? How many days have I given you so far? So why is the next 30 days going to be different than the 60 days before now? When did you get your job? A week ago, and where do you work? What? And what do you do for them? How much do you have saved? And you think that, and you think well, how much are you trying to save up to hire the attorney? Which attorneys have you talked to? Okay. And you said you owe him $800. How much does it take to retain him to represent you? Okay, and you've paid him 800. You've paid him 1,200. And you owe him 800. And you're telling me that if I give you 30 more days, that guaranteed. Or you'll come back and well, it doesn't work that way. You don't get to come in and decide I'm going to have an attorney that I'm going to hire, or I'm just going to have one that the taxpayers pay for. It doesn't work that way. The only way you're going to get a court-appointed lawyer is if you fill out the application and you're found to be indigent. That means that you don't have enough money to provide for your basic necessities and that you meet some poverty guidelines. Okay. So what could happen is if you come back in here in 30, if I give you this 30 days and you come back without a lawyer, what could happen is we have a hearing on whether you should be on bond or not, because you paid your bondsman. You got that money taken care of, didn't you? Yeah, you got that quickly because you wanted to be out. So I understand, but I'm saying in 30 days, if you come back and you have a job and you tell me now you have a job, you're going to keep that job, right? You come back in 30 days and you have a job and you don't have a lawyer, then I'm going to consider whether or not I should find your bail insufficient and just put you back in jail. And then if that happens, you may become indigent and then you may get that court-appointed attorney. But that could set your case out another 3 or 4 months. So I'm going to give you until January 5th. That's more than 30 days. January 5th. It's going to be your very last setting. Okay. January 5th, 9 a.m. And Mr. Patillo will be across the hall in that smaller courtroom. All right. Deputy Everett's going to fill out this notice of setting. You're going to sign that. He'll give you the yellow copy and you'll be free to go. Oh, yes. And let me tell you this, Mr. Patillo, I need you to do something today. Come on up here. I'm going to hand you this TRN processing order, okay? When you were arrested outside of Van Zandt County, right? All right. So when you were arrested there, they took your fingerprints.
Oh, my bad. You made me book in last time I came.
Okay, did you take that and go
Yes,
do
sir.
it? And
Yes,
did,
sir.
and they did that?
Yes, sir.
All right, well, give that back to me then. Well, I appreciate that. All right, so over there with Deputy Everett.
Yeah.
All right, court calls CR 2378 State versus Megan Nicole Bailey. All right, Miss Bailey was set today on the state's motion for continuance. The court has received notice that the state is withdrawing their motion, but it also received a request from the defense to maintain this setting on the state's motion. Is that correct?
Well, or just, you can say, I understand they withdraw their motion for continuance, so, and in talking with Ms. Heisel, I was expecting that there was a pretty high probability that Ms. Bailey's case would be going to trial on Monday. I know that may not be completely clear yet, but that would, hoping to get some clarification. And also, I was on the record with Ms. Bailey about, a couple of plea offers that had been made and just put on the record that she was not accepting those and that was still wanting to go forward with the jury trial. So that was the main reason I wanted to keep the hearing on the docket. But then also, yeah, still maybe see if there is any clarification about where we might be as far as trial goes next week.
Well, earlier today, the court took up several motions for continuance. So of course, looking at its top 10 list, the number one case, Mr. Ellison, that was set for trial, that has been passed by a visiting assigned judge. Mr. Hankins, there were motions for continuance by both the state and the defendant. The court has heard arguments on that and is taking that under advisement. Will issue a ruling later. Mr. Joel Downs, it's my understanding that that's going to be set for a plea next week or so. December 15th. That was the number 3 case. Mr. Murleader filed a motion for continuance on one, or actually he filed a motion for continuance on both of the cases for his client. The court's taken that under advisement after hearing argument. The state filed a motion for continuance on case number 5, which is Lewis Johns. Mr. Schmidt has not taken a position on that. The court's going to be ruling on that. That brings us to number 6, Megan Bailey. You're fine.
Okay.
So I don't know, Mr. Sanders. If I could tell you right now, I'm going to have to go back and consider their arguments in the case law they presented.
Okay. And I can tell the court that we're ready to proceed. And part of the reason I was looking for some clarification, I'm also set in the 241st for a jury trial Monday, but I've already filed a motion for continuance on that, partly because of the case here. So, and I know lots of things like this just kind
I
of.
think the customary practice is to file one in both.
That's right.
And just so I have you here, so the motions that were filed by the defendants higher up or lower down, however you look at it on the jury list, on the top 10, Mr. Hankins and Ms. Delaney, they both filed motions objecting to jury selection occurring at the First Baptist Church and then trial occurring at the JP3 courtroom in Wills Point. But jury selection is at the First Baptist Church Old Chapel. It's the only location I could find large enough to accommodate a large panel. Does your client have any objection to that?
Oh, no. I don't think we have it.
Okay. I just want to make sure I was going to be taking that up. And so while I was considering that, I wanted to know if your defendant was in that group also.
No, I don't think we have it.
Okay.
As far as that part.
Okay, so remind me again on the latter part of your announcement, you said that you wanted to talk with Miss Bailey to make sure that she still wanted to go to trial,
Yes.
considering the recent developments of the likelihood that she could be going to trial on Monday.
Yes, and then just to go over, I had received another plea offer from Ms. Heisel at the time that they were filing a motion for continuance, and we talked about that, but then when things changed and they withdrew their motion for continuance, I think they withdrew that offer anyway, but we weren't, from all my discussions with Ms. Bailey, she wasn't in agreement with that anyway, but I just wanted to put that on the record, just briefly.
You said she wasn't in agreement with the revised offer.
And Judge, I think the court can take judicial notice. We had a plea agreement worked out where we were actually in front of the court. I don't know if we actually turned in plea papers or not, but we were setting for a plea. And that did not end up happening. I think the offer had been the 3 years deferred.
And then there were some different extenuating circumstances, but ultimately that offer was rejected. And then more recently, Ms. Heisel had said that the state could reduce it to a Class A misdemeanor with her doing time served and then paying a $4,000 fine. But that would still involve pleading guilty to an assault, and we talked about that. And Ms. Bailey indicated to me that she did not want to accept that. And I think right around the time that we were talking about it, that's whenever Ms. Heisel said that they were going to withdraw that offer anyway. So we hadn't accepted anything that affected her withdrawal of that offer.
Okay. Do you need to put your client on the record at all, or do you need time to talk with her?
I may
And
just ask her just briefly, if what I said was all correct.
and Ms. Bailey, may have you just raise your right hand in case you're under oath. Ms. Bailey, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God. All right. And Ms. Bailey is only being called for a very limited purpose regarding admonishments about jury and trial next week. Is that correct, Mr. Chambers?
Yes, that's correct.
All right. Go ahead, Mr. Chambers.
Ms. Bailey, you heard my recitation of the previous plea offers that had been made in your case, correct? Okay, and then you also heard that from our discussion, you were rejecting those plea offers that had been pressed.
Yes, sir.
Okay. And is it your desire to proceed with the jury trial in your case?
Yes, sir.
And you've heard the judge kind of go over other cases that are set for trial next week, and whether those may or may not end up happening, but from our discussions, you're still wanting to proceed with the jury trial in your case?
Yes, sir.
Okay. All right. That's all I have.
Okay, all right, then, there is no motion for continuance, so I guess, we'll see Miss Bailey, you're scheduled to appear on Monday, regardless of whether you're selected for trial or not, so we'll see you, on Monday morning as previously noticed. And then as soon as I make rulings on these Mr. Sanders, I'll make sure that you and the state, I mean, the state's gonna know because they're involved in all the other cases, but I'll make sure that both parties know where we end up on this docket.
All right,
All right.
that sounds good to me. Thanks.
Thank you, Mr. Sanders. Do we know why we are saying, I mean, under the reason it's going? Did he say that? Yeah, but, oh, yeah, I'll need a reason. Ms. Pullings. All right, this is the sanctions court hearing. Yeah, absolutely. All right, Ms. Pullings, this is a sanctions court hearing. Ms. Pullings, we've been over the purpose of sanctions court, you and I, right? We've talked about what it is that you have to do to stay on probation, to try to stay out of prison. We talked about that you're on the state jail felony charge of abandoning or endangering a child. You went on in October of 21. You're set to expire October of next year. You're on deferred, meaning if you successfully complete all the period of your community supervision, then your case can be dismissed. Also that if you violate the terms of your community supervision, you could be brought back to court. The state could file a motion to adjudicate your guilt. The state could ask the court to do several things. One thing they could ask the court to do is to convict you of this offense and put you on regular probation. They could ask this court to convict you, revoke your community supervision, and place you in prison. If they were to do that, then you could be facing the entire range of punishment, which is the minimum 6 months to the maximum 2 years in prison. in state jail, and that's a day for day prison sentence. There's no parole. You understand that? Have you been to prison before? Do you want to see what it's about? You have a little baby here with you, don't you? Comes to court with you every time. Well, I mean, she got stomach virus. The purpose of sanctions court is to keep you on track to expire without extensions, to make sure you don't fall too far behind, to try to give you every opportunity to not violate and get a motion filed on you. You understand that, right?
I'll be no trouble, but with that showing up on my background, it's hard for me to find a job. So I pay what I can, and I'm gonna face that. I didn't do my community service because she got sick, and said that I could do it till tomorrow, maybe another day today.
10 hours of community service is not a whole lot. If you do a little bit every weekend, it's not that much.
I know the wrong thing I do that with that.
I understand the money issue. I do. I don't understand the community service. I don't understand that. There's all.
She was sick. But she was born with a condition that I can do right now until I give her right to go back today. I'm not gonna let her either. And I didn't even know my baby was sick. They had to tell me because I didn't feel fine.
When did she get sick?
On Tuesday.
Tuesday. What about all those days before Tuesday? Why didn't you do your community service all those days before Tuesday? We're talking about 10 hours, Andrea.
I've been trying to go to work, they're not coming enough. So I have to put in the hours that I can to pay my probation. And then do my community service. I'm one person, I don't have anyone. I'm a single mother, I'm doing the best I can.
Is the child's father paying you child support? Have you asked the Attorney General's office to file a suit against that father? Neither one of what?
They called, they phone, they went over there where they went in, they gave them the wrong address. I'm doing all that I can to take care of my kids.
Today, you're delinquent 60 hours on your community service. Over $600 on your money. How old's your baby? And you started this probation back in October. That was way before your child was born.
Sick, I couldn't work. Real sick, I couldn't even get out of bed.
I'm really coming at, I really don't have anything to offer you anymore. I mean, I've tried, I've told you. I don't know what's gonna happen. You may get a motion to revoke. The state may have to consider that. I don't know. As far as I'm concerned on the sanctions court, I don't know what else to do.
That's why I told her she went up on probation. Then I told her, like, I don't have that much money to be paying what you went up on. I can be paying that I was told today to be paying.
Well, you understand though, the reason the probation has gone up is because you didn't pay in the beginning. The probation hasn't gone up. You haven't paid. And so listen, all that you didn't pay gets carried forward. It doesn't drop off. It doesn't go away. So your payment that you had in October of 2021 versus your payment you're going to have in October of 2022 is different, because all of that is going to compound and it's going to get on top. It's just going to be added to it. That's why you're having to pay $140 to probation every month when it could have been 60. So no one's going up on it. No one's increasing.
When I pay, the money goes up. This should be 600 if I just paid.
Nothing goes up. No one's charging you more than what you were originally assessed. The reason the amounts go up is because you're supposed to be off probation in less than a year, like 11 months. You're supposed to be off probation. And we're trying to get you to a point to where when October rolls around, you're done with your probation, you've paid everything. Good job, Andrea. See you later, go live your life. Government's through with you because of your criminal charge that you accepted a plea agreement on back in October of 21. That's what we're trying to do here. No one's trying to take money out of your baby's mouth. No one's trying to do any of those things. And no one's increasing how much you owe. We're not playing hide the ball. We're not moving the target. We're trying to keep you on target. Okay, so I don't want you to think, well, she keeps on increasing it. No, she's not increasing it. You keep on not paying it. And when you don't pay it, it just gets added to next month and added to the next month. And yes, it gets bigger because if you don't pay that, you don't end on time. And when you don't end on time, you know what happens? A couple of things. Either one, you end up going to prison, which is not good, right? Or you get extended. And that extension means it costs you more money. Because then you have to be supervised, you have to be drug tested, you have to do all these things. So it's going to cost you not only your time and your liberty, it's going to cost you more money. And so that's what we're trying to prevent. People oftentimes walk in here and think that the government's just being real hard on, the probation officers being hard on, the judges being hard on them. And that's not the case. Okay. So I don't know what to do. I mean, your probation officer is recommending that I sanction you with 6 days in jail. That I send you to go to jail for 6 days and you figure out where to put your baby. But I don't know.
And I told her when I get my safety, I was gonna pay all this off.
Well, how does she know that? She doesn't know what you're gonna do until you do it. Okay? You can't just take people at their word on what they're gonna do. Okay?
I don't understand it, and I don't get in no trouble. I mean, I told her it's hard for me, I don't have to.
Understand, we didn't create your life circumstances. Okay? I'm sorry that you find yourself in that position, but we didn't do that. We didn't make you responsible for abandoning, endangering a child and pleading guilty to that. We didn't do that. It's not our child. We're not the ones not paying child support. I'm sorry for your life circumstances, but those are your choices that you made. All right. And those choices have consequences, and all those consequences are coming to bear right now in your life. And I'm telling you, Andrea, I don't know what to do. I don't want to see you go to prison, but if you don't do these things, they're going to be violations of your probation. And that really ties the hands of the DA's office, of the court, of the probation. We don't know what to do. So this is what I'm going to do for you today, because I don't know. I'm going to reset you to January 24th. And I'm not going to tell you to do anything. I'm going to see what you do. They're going to see what you do. You're going to decide what you do between now and January 24th. And that's going to make the decision you're going to make the decision what happens next in your life. Either you're going to come in and you're going to pay off a bunch of stuff and you're going to do your community service and show people you're serious about it, or you're not. And if you do that, if you show that you're trying, then it's going to change the nature of this conversation in January. If you come in and you say, hey, I can't do it, don't have enough money, don't have enough time, then that's also going to decide what happens to you next. Okay. So this is the first time I've ever had a sanctions court hearing where I haven't said, this is what I expect you to do. Because, frankly, I've done that several times and it's getting no results. So it really makes no sense for me to continue to do it. So I'm just going to reset you to January 24th. I'm not going to make you do 6 days in jail. I'm not going to make you pay $140 to probation. I'm not going to make you pay $230 to your court collections. I'm not going to make you pay 10 hours of community service. I'm not going to make you work 10 hours of community service. I'm not going to say you have to do that. You're already ordered to do it. If you don't do it, you're probably going to get a violation. And the next time you show up in here, you'll be in an orange jumpsuit. It'll be in the afternoon and you'll be on a Zoom screen, and we'll be talking about how long you stay in jail or if you go to prison. Come over here with Deputy Everett, sign this notice that you're going to be back on January 24th. Make sure I put 23, Brian. I probably put 22.
You put 22, but you also put 7 a.m.
Let's get here early. You sure it's, my handwriting's probably bad. It should be, it's a 9. I did 1 year of medical school. It's a joke. I'm not smart enough to do medical school.
Your Honor, her response is not satisfactory. We will file a motion for adjudication.
Thank you, Ms. Graham. Ready to go. Mr. Manning, are you ready?
Yes, sir.
Are you ready on, sir?
Mr. McFarland?
Mr. McFarland? Take your time, sir. Don't rush. And be careful coming up. This is cause number CR 22-335, State versus Benny William McFarland,
Yes, sir.
and we're set for pretrial.
That's correct, Judge. I have gotten some of the discovery in this case. I haven't.
And Mr. McFarland, if you need to sit down, you're welcome to do so, sir. And if you change your mind, you just seat yourself, okay? Go ahead, Mr. Manning.
Discovery in this case, I haven't had an opportunity to go over that with Mr. McFarland, so I request that we have additional pretrial in this case for review discovery and discuss our pretrial.
Any objections from the state?
No.
All right, court will reset Mr. McFarland for an additional pretrial to allow defense to continue reviewing discovery with the defendant. Mr. Manning, have I set you already this morning for the 24th?
Judge, I believe.
I think I did.
I believe we did. I know, January 9th, February 9th.
Maybe I haven't. Is January 24th acceptable?
I believe so, that's Thursday, that's correct.
Oh, you know what? I'm sorry. No, that would be a Tuesday. We'll just do that February 9th.
Okay.
Keep you on that Thursday. All right, that'd be February 9th at 9 a.m., Mr. McFarland. And I'm not. We hope and pray that we'll be back upstairs in our courtroom, so just plan on reporting here. If that's not going to be the case, we will notify Mr. Manning and your bondsman and let them know.
What's it called? Mr. Derek Bolden.
Mr. Bolden?
And Judge, I have a brief announcement on the Mr. Bolden was recently appointed to me on a motion to revoke. On reviewing that motion to revoke, it was found that the only delinquency for violation was a failure to pay. We received that amount from the probation department, and Mr. Bolden paid that amount. We can show that, paid that amount total. We just found out yesterday that there was some discrepancy or delinquency with the court collections office of amount of $508. Mr. Bolden and his wife believed that had been paid previously. There was information given to us this morning that some of those payments may have been going to the county clerk instead of going to the district clerk. That's been confusion as getting those on the right books for the right case. And so we request that the ED resets the February date for us to first of all clarify that, and if not, for him to pay that, if there is a balance for him to pay that amount for every day.
Any objections? All right, thank you, Mr. White. All right, Mr. Bolden, court will reset you to February 9th. And that'll be at 9 a.m.
And just like I said, he did make a payment of $1,100, which was the entirety of the probation fund. And he's tapped out right now. Otherwise, he would just probably.
Understand.
Miranda O'Brien.
That was upright. The Opry or Opry?
It's O'Brien.
Opry, is that right? All right, this is cause number CR 22-280, CR 22-281, State versus Miranda Jill Opry.
Judge, Ms. O'Brien has an appointment to meet with me tomorrow at 2:30 to go over her discovery and discuss. She has some possible offenses that she would like me to look at, so request additional pre-trial.
All right, court will reset Miss Opry to February 9th at 9 a.m. Look. John Lejean. Mr. Lejean, all right, this is State versus John William Lejean Jr., CR 21-402 for docket call.
Yes, Judge. Mr. Lejean is providing with some medical paperwork today that indicates he's going to be needing to have surgery to correct a fairly serious situation. He is going through process with Mr. Waddell to apply for indigent health through the county. And we would ask that this all be reset for him to get that taken care of before we proceed either to a jury trial or with a plea for time.
Is the medical procedure something that would prevent him from preparing for trial, or what's the time on that? I mean, if he's not going to accept an agreement and we're setting for jury selection, and he's looking at probably a year before he gets a jury trial, will his medical issue be resolved within that time?
Yes, Judge. My understanding from what he told me the time this morning is that they hope to have an answer from the indigent medical services in 2 weeks. And then he'd be 2 to 3 weeks, and then he'd be able to proceed with the surgery after that.
And does the medical issue in any way impair his cognitive ability to?
It does not.
Okay.
It's merely a physical issue.
And so has an offer been extended to the defendant that he's?
There has been an offer extended. We've discussed that offer, and we've gone over the paper discovery. However, we've not reviewed the video, and the plan is requested for review the video before he finally rejects.
How many settings? I show this is our 9th setting with Mr. Lejean.
That's correct. I've been on his case most, if not all, of that time.
And when did you receive the plea offer? Or when did Mr. Lejean receive it?
We received a new plea offer at our last setting for TDC. And that was the last offer that's been received. We continued negotiations, but state's pretty set on the 14th.
State, is that your final offer, the best offer?
Yes, sir. Yes, sir.
And is Mr. Lejean in a position where he can make an announcement today whether he would accept or reject? I understand when you're asking for an additional docket call. I'm trying to find the reason for that. If it's a medical issue that's not going to affect his ability to accept or reject today, and it's not going to prevent him from going to trial, which would be a year away, then.
My concern is this, Judge, that if he rejects the plea today, announces ready for jury trial, and then something changes on us being able to do the video, and him change his mind on the safe offer. My understanding from the court's policy is that he would not be able to accept that offer after we announce ready for trial today. That's his medical issue has been what has been preventing him over the past few weeks from coming to visit me for the last court setting. He has emailed me, reached out to me. We've been in contact because of the medical issue. He's been unable to come to the office. We have reviewed the paper discovery, just not.
If he has this medical procedure, how long will he be out recovering from that?
I'm not sure.
You got an estimate?
He believes it would be 3 months.
So you're asking for a 90-day reset.
No, Judge, just a normal reset, so that we can see. First of all, get him in, to review the video. Second of all, discuss the offer. Third of all, see when he's gonna have that strict reset. If that's gonna be able to happen, in a timely fashion, or this can be pushed back.
Judge, it seems to me that maybe, a short reset to allow him to watch the video, but if he's inclined to accept the plea offer, it would, unless this medical condition is life-threatening, would sure make a lot more sense for TDC to be funding that in taxpayers and things.
Not a bad idea. All right, the court's going to grant your request for an additional docket call to Thursday, January 5th. That'll be at 9 a.m. And I believe on the 5th will be across the hall, Mr. Lejean in the county court, the smaller one. Yeah, just come right back to this area.
And Judge, I've been informed that Mr. Jones, I haven't seen Mr. Jones up. Mr. Jones is here, and this is my first appearance with him last, my court appearance. So I think we're, why he's unable to be here.
Mr. Jones, come on up.
Excuse it for.
All right, this is clause numbers 2021 540, 541, CR 21-328, State versus Dennis Ray Jones. Mr. Jones, why were you late to court today? Where was she in the hospital at? And you had to go pick her up? You were going? And why is she in the hospital? You don't know? You do know? Go ahead, Mr. I'm going to finish that conversation and then go ahead, Mr. Manning.
Judge, this is my first time, like I said, appearing with Mr. Jones. I have not had any direct contact with him. I was appointed in his case after a previous attorney withdrew. And so I would, in reviewing this case as well as having an offer, I'd like to actually reset this for pre-trial. I've discussed that with Mr. Woodwhite to review, because this case, it looks like is going to be, or has been enhanced to a second-degree felony. And so I'd like a chance to go over with my client and present some defenses through motions.
All right, the court will grant your request, Mr. Manning. Court will reset Mr. Jones for, you wanted pretrial, correct?
That's correct, Judge.
We'll set that February 9th. That'll be at 9 a.m. or 1:30 if Mr. Jones is in custody. Mr. Jones, I have a note here that you failed to appear for jury selection on October 13th. Why was that? Excuse me?
Here?
Yes. I have a note that you failed to appear for jury selection on October 13th for jury selection.
They moved it, they sent me some of the paper in the mail, they didn't know, they changed the date.
Yeah, he was on your selection docket, and so I requested the court to put him on docket call, so that we could see what the status of the case is.
Okay. And what about your financial delinquency? When's the last time you made a payment to? Well, just answer my questions. When's the last time you made a payment to pretrial? Been a couple months ago. That's a couple months too long, because you're ordered to pay. Hang on, quit apologizing. Listen, you're ordered to pay every month. And you're not. Why are you not? So you don't have a job, you don't have any money. All right, so this is what I want, Mr. Jones, I want you to go, is Mr. Waddell, I want Mr. Jones drug tested this morning. So Mr. Jones, you're not free to leave. I want you to go with Mr. Waddell. After he's done with you, I want you back in the courtroom and we'll finish that conversation after the drug testing.
Judge, ready for, yes, Jones.
Sanaya Jones, CR 22326. Is this a plea today?
Yes, Judge. Oh, I forgot, I'm sorry. So we still doing this at the jail. I did not get the states.
That's fine.
I did get her sworn to though.
That's good. We call that substantial compliance.
Yeah, it's substantial.
Ms. Jones, while we're waiting, if you'll raise your right hand, ma'am. You are Sanaya Diane Jones, correct? Ms. Jones, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God. All right, thank you. You can lower your hand. Make sure you speak up loudly and clearly for me so my court reporter can hear you, okay? All right, Ms. Jones, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
And have you ever been diagnosed with any type of mental condition? In this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with his representation of you?
Yes, sir.
Do you feel like you've had enough time to talk with Mr. Manning about your case and have all of your legal questions answered?
Yes.
Is there anything about the paperwork that you've read over and signed with him today that you do not understand? Mr. Manning, do you believe Ms. Jones to be competent today?
She is, Judge.
You've explained to her the rights that she has pertaining to this case, the plea agreement, and any waivers of rights pursuant to this plea agreement. Is that correct?
I have, Judge.
And you believe that she understands what she's waiving today?
She does.
Ms. Jones, it appears that you were charged by indictment with a third-degree felony offense of possession of a prohibited substance or item in a correctional facility. A third-degree felony carrying a range of punishment of 2 years to 10 years in prison. However, it looks like the plea agreement today that you're asking the court to approve is for you to plead guilty to a lesser included offense of criminal attempt of prohibited substance in a correctional facility, and then be prosecuted under section 1244A of the Texas Penal Code at 2 days confinement in the county jail, with you receiving credit of 2 days already served, being ordered to pay a $1,000 fine, $290 court cost, plus reimbursement fees of $535. And the state would be dismissing pursuant to this plea agreement a felony possession of, I'm not sure, felony possession of controlled substance less than 1 gram, a driving while license invalid with previous conviction, and a reckless driving. Is that your understanding of the plea agreement?
Yes, you are.
All right, and Ms. Jones, at this time, I'm going to ask you, well, and let me advise you that the range of punishment under a 1244A state jail is a maximum jail sentence of not more than 365 days, and a fine not to exceed $4,000. Do you understand that range of punishment?
Yes.
And so the court would find that this proposed plea agreement would lawfully fit within the range of punishment. Ms. Jones, how do you plead to prohibited substance in a correctional facility by attempt? Are you pleading guilty to that crime because you are guilty of that crime? And has anyone threatened, forced, or pressured you to plead guilty to this offense? The court will accept the defendant's plea of guilt. Mr. Manning, any objection to state's evidence?
No objection, State.
All right, states one is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor. The rest of those are the same.
From the defense? All right, court will review the evidence. All right, the court has reviewed the evidence. Court does find sufficient evidence to convict Ms. Jones of this offense. Court will follow the plea agreement in this case. Court hereby convicts Miss Sanaya Diane Jones of attempted prohibited substance in a correctional facility, a state jail felony. Court will approve the prosecution under section 1244A of the Texas Penal Code. Court assesses her punishment at 2 days confinement in the county jail, with her receiving credit for 2 days of time served. And the court will dismiss the cases previously mentioned by the court and indicated in the judgment of conviction. The court orders Ms. Jones to pay a $1,000 fine, $290 court cost, and $535 reimbursement fees to Van Zandt County. Mr. Manning, would the original THC cartridge been a misdemeanor offense?
Judge,
I think it would.
don't believe so.
Think it would have been a felony either way.
With the way they're testing them, most THC cartridges are going to felony.
And Mr. Manning, do you know if Ms. Jones is going to be able to make any payments today towards what she owes the county?
Judge, at least you're gonna make a day payment if you didn't need it. Have it shut there every possible.
Ms. Jones, how much can you pay today? 100? Okay, I'm gonna order you to make that payment today and then go up to the court compliance officer, Miss LaPrade, upstairs at the end of the hall on the west end, and talk with her about setting up a payment plan for the remainder of what you owe. And unrelated to this case, and in no way will affects this case or the judgment. Ms. Jones, are you the same Sanaya Jones that was involved in call of law enforcement? And that's you, correct? I thought that was you. And you were you 18 or 19 when that happened? 17. It's not good to see you here again. Seems that you're somewhat memorable. That's not a good thing for a judge. It's not a good thing. All right, Ms. Jones, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. All right, step forward with Deputy Everett to be fingerprinted. Mr. Sanders. Michael Dean Sanders, CR 22228. All right, Mr. Sanders, if you'll raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? You can lower your hand, you speak up loudly and clearly. Mr. Sanders, are you a United States citizen who reads, writes, and speaks English? Yes, sir. And have you ever been diagnosed with any type of mental condition? And in this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning as your attorney? Do you feel like you've had enough time to talk with him about your case and have all of your legal questions answered? Is there anything about the paperwork that you've read over and signed today that you do not understand? Mr. Manning, do you believe Mr. Sanders to be competent today?
Yes, Judge.
And you've explained to him his rights as they pertain to this plea agreement?
I have.
You believe he understands his rights and what important waivers he's making today?
I do.
All right, Mr. Sanders, it appears that you were originally indicted with a felony offense, a state jail felony offense of possession of a controlled substance, penalty group 1, less than 1 gram, which would carry a range of punishment of not less than 6 months in prison up to a maximum 2 years in prison and a fine not to exceed $10,000. I see here that you want to enter into a plea agreement wherein you would plead guilty to that offense. The state's recommending that you be prosecuted under section 1244A of the Texas Penal Code, which if the court approves, means that you would be convicted as a felon today, but you would be punished as a misdemeanor offense. And your plea agreement is for 32 days in the county jail with credit for 2 days, meaning you would have to serve 30 additional days, a $2,000 fine, $180 restitution, $535 reimbursement fees, and $290 in court costs. And the DA's office is agreeing to dismiss and consider a tampering or fabricating with physical evidence. And you would be required to submit yourself to the Van Zandt County jail. Well, you'd go into custody today, correct?
That's correct.
I hadn't read all the way through, so I didn't know if there was going to be another date. Mr. Sanders, is that your understanding of the plea agreement and what you're asking the court to approve?
Yes, sir.
All right, Mr. Sanders, as to possession of a controlled substance in penalty group 1, less than 1 gram, how do you plead? You plead guilty to that offense because you are guilty of committing that crime. Has anyone threatened, forced, or pressured you to plead guilty today? Court accepts the defendant's plea of guilt. Mr. Manning, any objection to states 1?
No, Judge, say so.
States 1 is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Briefly, Your Honor, the defendant is going to be paying, I believe, $2,000 today. We did reduce the fine because he is going to pay all that upfront. I do believe he will be paying on court costs, but he will be making a very substantial payment. We have lowered the fine because of that. Beyond that, we're not.
Okay. Anything further from the defense? Okay. Court's going to review the evidence. All right, court has reviewed the evidence. Court does find sufficient evidence to convict Mr. Sanders of this offense. Court will follow the plea agreement in this case. Court hereby convicts Michael Dean Sanders of possession of a controlled substance in penalty group 1, less than 1 gram. Court assesses his punishment under section 1244A at 32 days confinement in the county jail. Court will award 2 days credit to Mr. Sanders towards his incarceration for time previously served. Court orders him to pay a $2,000 fine, $180 restitution. Court takes into consideration and dismisses DA 2022-0376, a tampering or fabricating with physical evidence. Mr. Manning, is Mr. Sanders going to be able to have someone pay that on his behalf today, or is he going to need to pay that before he goes?
Yes.
All right, and in payment of the financial obligations, I would ask that priority be given to the reimbursement fees to Van Zandt County. First and foremost, before paying the fines. I want to make sure that the restitution and reimbursement fees are paid before the fines and court costs.
And Judge, I don't know how the courts take that payment. I know they have their system, so.
Yeah.
I will let them know that's your preference.
Thank you. I just want to make sure that Van Zandt County gets what it's owed before the state starts taking its portion. All right, Mr. Sanders, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. Deputy Everett will fingerprint you and take you into custody at this time. You ready on Mr. Manning?
Judge, I see that Mr. Jones is back here as well as Mr. Price. Mr. Price is the one that, he was going to go into custody today, but we're going to extend that. So I just enjoy the paperwork. That will be available.
What about Miss Rios? Has she appeared at all?
Judge, my understanding is that she contacted her bond and is providing paperwork that she has the flu. And supposed to be providing them paperwork. I have not seen any information on that, but that information was provided after.
All right, so let's see. Mr. Manning, Mr. Manning, can you approach? No. Not yet. Oh, never mind. That's what I was gonna make sure you're aware of.
I had a suspicion.
Okay. All right, Mr. Jones. All right, we are back on the record. In cause numbers 2021-540-541, CR 21-328, State versus Dennis Ray Jones. The court has ordered Mr. Jones to submit to a drug analysis test today. Mr. Waddell, have you administered that test to Mr. Jones?
Yes, Your Honor.
Okay, and what were the results of that test?
The results of the test was he was positive for methamphetamine as well as benzodiazepine.
And did you have any discussions with Mr. Jones regarding the results of the test?
Yes, Your Honor.
And is there any logical or plausible reason why he would be testing for these substances?
No, Your Honor.
Mr. Manning, do you want to take any testimony from Mr. Waddell? I haven't sworn him in. I'm just getting an update on the test.
Judge, I don't believe based on the provision, he provided me with a specimen information sheet. It appears to, I guess my only question would be, is this Mr. Jones' signature on this admittance form?
Yes.
Okay, and did he sign that in front of you?
Yes.
All right, Mr. Jones, you know what's next. All right, Mr. Jones, I hereby find that you have violated the conditions of your pretrial release. The court finds that based on the urinalysis test and your admittance to having smoked methamphetamine on November 30th, 2022, being yesterday, court finds that you have violated the pretrial release conditions of this court. And the court's going to find your bond to be insufficient at this time, and the court orders you into custody. Deputy Everett. Yeah, with the order. Yeah, I'm gonna get Patty to get the. I did Chavez, I did 124, right? Okay, and on Andrea, I said 124. Yeah, about that. Let's put our heads together on it. So let's put our heads together on that real quick. Yeah, Mr. White, are you ready?
Would we, for the, we call everything first,
Yes. Who do you want first?
we call, Mr. Peterson.
Cottrell Hickerson, CR 22-105. All right, Mr. Hickerson is set for pretrial.
Your Honor, we have not filed any contested pretrial motions or by the court's, standing pretrial orders in regards to discovery between, today, we have to move this over to the docket call.
All right, court will set Mr. Hickerson for docket call, finding there are no contested pretrial motions. Are you available? Do I have you coming back on January 5th?
I believe so, yes.
I've got the 5th or I got the 24th if you want to, if you need to check your calendar.
It's. That'd be good, maybe he's going to say. We do this one for you.
Yes, court sets Mr. Hickerson for Tuesday, January 24th at 9 a.m. Ready to go.
Do we call this Price?
Wendy Price, CR 22-339. This price is set for pretrial.
Your Honor, I filed a pretrial motion for discovery. Now. It's closer to the court. I tried to file that on Wednesday before Thanksgiving. And this is why my paralegal doesn't let me file because I put it in draft. And when we realized that on Monday, we filed it. I'd already discussed the matter. It's a basic blood discovery motion asking for the lab records. I just talked to Ms. Eisner prior. I told her what I was going to do. So usually she just calls over there and gets that for me. I think they should have it by January 24th. Sometimes it takes. Yeah.
So you're not asking for any type of hearing on that. You believe that you believe the state's complying with that? Okay.
Judge, I believe we are in the process of requesting that and we have requested it. It should be.
All right, we'll reset this for an additional pretrial awaiting that production of that discovery. And we will set Ms. Price also on January 24th. Who's next, Mr. White?
Mr. Castillo.
Mr. Castillo? This is CR 22-319, State versus Gustavo Miguel Castillo, set for pretrial.
Your Honor, the state has made us an offer on this case. We're going to be discussing, we're asking court to move it over to docket call. We don't have any contested motion. We're denied by the state for the court standing order regarding pretrial matters. And ask the court to move this over to 24th.
All right, court will find there are no contested pretrial motions and we'll set docket call January 24th at 9 a.m. Mr. Castillo? Hang on just a second. So, Mr. Castillo, I've got 2 warrants for your arrest. KPS profile warrants from CR 1260, CR 16165. It looks like you owe about $400 that you haven't paid the county. So, well, that's okay. That's okay. Get Mr. White, Mr. Castillo, y'all come forward. Mr. White, y'all come forward. I know. I know. So what I'm willing to do is let you go upstairs and talk. I'll give you these. You can take these upstairs and meet with Miss LaPrade. She's at the end of the hallway. And this is what it's showing. It's 234 on this case, 149 on this case. So it looks like you paid most of it all.
like 7 things.
Yeah. So this might just be a little bit of an oversight. So, but unfortunately, it comes through the system like this. So I'm not gonna execute the warrants on you right now. Do you think you could pay this today?
I've seen talking a lot of that.
Yeah.
So just make sure.
Sure.
Yeah.
If not, then what I'm gonna want you to do is I'm not gonna execute these on you, but I want you to go upstairs and make whatever payment you can, and then meet with Miss LaPrade, make sure she has your most updated contact information. Okay. Because I looked at it and I thought, well, you've had substantially paid most of that, so I think it, plus our jail probably wouldn't want me putting you in custody on that, but here, I'm gonna go ahead and give you this. And I want you to immediately just go upstairs. Meet with Miss LaPrade. She's gonna be right up, but just go up those stairs, and when you come up, take a right. Meet with her. Go quick because it's she's got lunch in about 7 minutes. Okay. And then if y'all can take care of it today, take care of it today. Otherwise, talk to her about it and let's get it squared away.
Okay, so thank you very much.
Go ahead.
Cool.
Hey, ma'am. Yeah, I'm gonna punch you in the face next time I see you. Hey, let Bonnie know that. Okay. Okay, good. Thanks. Bye-bye. Mr. White, who are you ready on next?
Could we take care of Ms. Miles?
Lanaria Miles, CR 2238 and 39. All right, it's Miss Miles, a plea.
Well, Your Honor, state made us an offer. I communicated that offer to Ms. Miles. Ms. Miles and family would like me to go over some things with them, including video. Talked to Mr. Woodwhack about that. I don't believe the state has any objection, but he indicated to me that the state position on this matter would be that they would agree to one more reset. The court was willing to do that. But at that point, that would be a final reset, and under no circumstances would they agree to it differently. Is that correct, Mr. White?
Mr. White, is there any reason that Miss Miles hasn't already come to this decision and reviewed the evidence? And is there any reason where she's waiting till the last minute?
Well, that regarding that has something to do with that. We didn't, there was an initial, we had initially spoke about the matter, Your Honor. I came back, I guess, earlier this week, and we came to an agreement. I called Ms. Miles later, as the court's aware, I've been out of the office a couple of days. So I tried to get it all done on Tuesday. But I wasn't able to get them in. They didn't indicate if they wanted to see the video.
All right, court's going to grant a final docket call on January 24th at 9 a.m. January 24th. This means that we don't know what we're going to be on those days. It's old. It's no big deal. I was just wondering, who was in here? I haven't been acting on it. I was just wondering. If we knew we were gonna be, I'm trying to tell these people. Who would you like next, Mr. White?
Mr. Dawson.
David Dawson? CR 22-324. Mr. Dawson set for pretrial.
Your Honor, we're not having pre-file. The state and I, we come to an agreement, the state's gonna have to refile, there's an unfiled misdemeanor in this matter. State's gonna refile that, we're gonna be proceeding on that. As a condition of the plea, Mr. Dawson is gonna have to pay all his fine and court costs up front. And it's gonna be a max fine and court cost. He flies here from New York. He indicated to me that he believed he had 90 days.
Judge, I believe that's our agreement. I didn't know the exact time frame, Mr. White. So we just extended reset, given that he is out of state. We're not opposed to that. The court's.
I mean, I typically don't do 90 days unless there's a waiver of jury trial, but y'all believe that this will be resolved? March 7th or 9th would be right at the 90 days.
March 7th,
All right, court sets Mr. Dawson then for plea before the court on March 7th. You're welcome. Who do you like next, Mr. White? Okay. Good.
Mr. Castillo, his wife's going to move. She's getting.
I trust she'll take care of this. Yeah, it's okay. Yeah, you already reset. Preston Schwartz. Are you Preston Theodore Schwartz?
I am.
Mr. Schwartz, if you'll raise your right hand, sir, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? Thanks, sir. You put your hand down. Mr. Schwartz, it appears that you have been indicted with a third-degree felony offense of possession of a controlled substance between 1 gram and 4 grams. A third-degree felony in the state of Texas carries a range of punishment of not less than 2 years or more than 10 years in prison if you were convicted and sentenced, and a fine not to exceed $10,000. Do you understand that potential range of punishment that could be applied to you?
I do, Your Honor.
And Mr. Schwartz, are you a United States citizen who reads, writes, and speaks English?
I am, Your Honor.
And have you ever been diagnosed with any type of mental condition?
No, Your Honor.
In this case, you have an attorney, Mr. White. Are you pleased with his representation of you?
Yes, Your Honor.
You feel like you've had enough time to talk with Mr. White about your case and have all of your legal questions answered?
Yes, Your Honor.
Is there anything about this pretrial intervention contract that you've read over and signed today that you do not understand?
No, Your Honor.
Mr. White, have you explained to Mr. Schwartz his rights as they pertain to this contract, the waivers he's making in regards to this contract? And if so, do you believe that he understands them?
Yes, Your Honor, I explained those, I believe these waiver rights, no one will be voluntarily. I explained to him that a waiver of jury trial is final, that he can't get that back, that nobody can force him to do it, you, me, or the state. He did that knowingly and voluntarily as well. I also explained to him that this is a limited expunction, meaning that the state and being the district attorney and the probation office can keep their records, but everything else will be expunged
All right, thank you, Mr. White.
on completion.
And that's your understanding, Mr. Schwartz?
That's my understanding, Your Honor.
And what Mr. White said about your waiver of jury trial, you agree with him on that?
Yes, Your Honor.
You understand that that right can be taken away from you, but you can waive it so long as you're waiving it of your own volition. That you're doing it intentionally, knowingly, and voluntarily, and you've understood this case and you're waiving your right to a jury trial today. Is that correct?
That's correct, Your Honor.
All right, the court will find that Mr. Schwartz has been admonished regarding his right to a jury trial in open court, that he has received counsel, the assistance of counsel in that waiver, and the court will approve the waiver of the jury trial. Court will also approve the waiver of speedy trial and the limited waiver of expunction. I see here that the pretrial intervention contract is for a period of 1 year. And and there's also restitution of $180, which would be a term of the contract. And Mr. Schwartz, you understand that if you were to violate any of the terms of this pretrial contract, the state could ask the court to redocket this case, bring you back, and allow them to continue their prosecution. And in doing so, you could be subjected to a bench trial before the court. You understand that?
I do, Your Honor.
And you understand that at that bench trial, the state could offer evidence that you've agreed to its admissibility in this contract. Those things that have been attached, including the indictment, any offense reports, lab reports, you're understanding that you're stipulating to this court that you agree that that evidence could be used against you in a bench trial.
I do, Your Honor.
And Mr. Schwartz, has anyone, threatened you, forced you, or pressured you to make you feel like you had to make any of these waivers today or enter into this contract?
No, Your Honor.
And you're doing this because this is what you want to do.
My relation, yes, Your Honor.
All right, court will find that Mr. Schwartz is competent and that he is entering into this agreement intentionally, knowingly, and voluntarily, and the court will approve the placement of Preston Theodore Schwartz on the pretrial intervention contract.
All right, go to the court and for the district attorney that you go to the district attorney's office. And committed this $500 pretrial intervention.
Thank you, sir. All right, Mr. Schwartz, I have signed my paperwork in this matter, so what's left is for you to report to the probation department, and they'll give you more information about the next steps, okay?
Thank you, Your Honor.
You're welcome, sir. Come over here and step forward, talk to these ladies, and they'll tell you where to go next. Monty Travis Austin. All right, this is cause numbers 2022-78 and CR 22-166. Mr. Austin, if you'll raise your right hand, sir. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God. All right, you can lower your hand. Mr. Austin, are you a United States citizen who reads, writes, and speaks English? And have you ever been diagnosed with a mental condition? And you're represented by your attorney, Mr. Nolan White. Are you pleased with his representation of you? Like you've had enough time to talk to Mr. White about your case and have all your legal questions answered? Anything about the paperwork that you've read over and signed with him today that you do not understand? Mr. White, have you explained to Mr. Austin his rights with regards to this plea agreement and also the advantages and disadvantages of a deferred adjudication?
Absolutely, Your Honor, he was right, knowingly and intelligently, voluntarily, and he understands what happens on a deferred adjudication. Most notably, he violates his term of condition for a period. Court finds that he actually did violate his probation by preponderance of the evidence. Court can adjudicate him guilty and assess the maximum punishment in this case, which is up to 10 years.
Thank you, Mr. White. You understand that, Mr. Austin? Okay, Mr. Austin, the range of punishment for a third-degree felony possession of a controlled substance in penalty group 1 between 1 grams and 4 grams is not less than 2 years in prison and not more than 10 years in prison, and a fine not to exceed $10,000. So as Mr. White aptly put, you understand that that's the potential range of punishment that this court could sentence you to if it later finds, after hearing an evidence, that you violate any condition of your community supervision. All right, understanding the plea agreement, understanding the range of punishment, then Mr. Austin, how do you plead to that third degree felony offense. Pleading guilty to that crime because you are guilty of committing that crime and for no other reason. Has anyone threatened, forced, or pressured you to plead guilty today? The court does accept Mr. Austin's plea of guilt. Mr. White, any objection to the state's evidence?
No, sir.
You may. Sorry about that. All right, are you Mr. Trammell Dwayne Price? All right, Mr. Price, if you'll raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, thank you. You can lower your hand. Mr. Price, are you a United States citizen who reads, writes, and speaks English?
Yes.
Have you ever been diagnosed with a mental condition? You're represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning's representation? Do you feel like you've had enough time to talk with him about your case and have all your legal questions answered? Do anything about this paperwork, Mr. Price, that you've read over and signed today that you do not understand? Mr. Manning, do you believe Mr. Price to be competent today? And have you explained to him his rights as they pertain to this plea agreement? And you believe that he understands those rights and he understands the waiver of the rights that he's making today? All right, Mr. Price, it appears that you were originally indicted with a third-degree felony offense of injury to a child or elderly or disabled individual with family violence. Appears that the plea agreement you've worked out with the state is for that charge to be reduced to a lesser included offense of assault causes bodily injury of a family member, a Class A misdemeanor. The range of punishment for a Class A misdemeanor is confinement in the Van Zandt County Jail for up to 365 days and a fine not to exceed $4,000. Do you understand that range of punishment? I see the plea agreement is that you would be pleading guilty to that offense in exchange for the recommendation that your sentence be assessed at 15 days in the county jail. You would receive credit for 8 days of time served. You would be ordered to serve the remaining 7 days on the schedule as set forth in the plea agreement. In addition, you would be ordered to pay a $3,000 fine, $535 in reimbursement, and $270 in court costs. Is that your understanding of the plea agreement?
Yes.
And that's what you're asking the court to approve?
Yes.
All right, Mr. Price, understanding the plea agreement and the range of punishment, how do you plead to assault causes bodily injury of a family member?
Guilty.
Are you pleading guilty to that crime because you are in fact guilty of that crime and for no other reason? Has anyone threatened, forced, or pressured you to plead guilty today? The court will accept the defendant's plea of guilt. Mr. Manning, any objection to the state's evidence?
No objection.
All right, state's one is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from state?
Judge, we believe they're checking on victim compliance. I believe we received an application. Immediately from the as well. Going to the courts.
My recollection is that there was a affidavit on prosecution filed. That was followed. I believe that that's what's followed.
Judge, our victims system coordinator is going to be telling us this. It's my understanding that the guy is very favorable to the defendant. And we also do have a application as well. So the state is in compliance. We just need to get that related to the courts. We can have the court consider that in.
Is there any request in the victim impact statement that's not being provided for in the plea agreement that the court would need to defer ruling?
I believe that this is Ms. Heidel's case, but I do believe it's well within what the victim would like to see happen.
That is a little bit harsh on the victim, but we have done lots other round. They wanted to finish their addition. That's what you can do.
Okay. All right. Anything further from the defense? All right, court's going to review the evidence. So the victim in this case is not the father, but his brother. Is that correct?
Stepfather.
Stepfather? Oh, the reporting party was your brother. Your brother's the one that called the police. Okay.
We discussed that.
All right, court has reviewed the evidence, and based on the statements of the DA's office as officers of the court will approve the plea agreement, will follow the plea agreement in this case. Court hereby finds that there is sufficient evidence to convict Mr. Trammell Dwayne Price II of assault causes bodily injury of a family member. The court assesses his punishment at 15 days confinement in the county jail, issues him credit for 8 days, orders him to serve the remaining 7 days as laid out in Exhibit A. The court also orders him to pay a $3,000 fine, $270 court costs, $535 reimbursement. Mr. Price, when you submit yourself to the jail, you'll need to bring a copy of your paperwork, including your order of commitment. And you also need to bring a photo ID so that they will know that you are who you say you are. If you don't bring those things, they're not going to let you in. And if you don't bring those things like I'm ordering you to do, then they're going to report it to me that either you didn't show up or you didn't show up and bring the things you're supposed to do. And that would be a violation of the court's order. Okay. All right, Mr. Price, you're hereby remanded to the custody of the sheriff so we can carry out the terms and conditions of the sentence. You'll come forward to be fingerprinted. All right, Mr. Manning, let's go ahead and reset Kevin Ehrenfeld, CR 22270. The court has confirmed that he's in custody in Rains County. So we'll just reset him for pretrial and status of custody. Let's do the February 9th. Ehrenfeld.
I don't have it right.
CR 22270. And Michael Lobb, did you ever get any more confirmation or anything on him? All right, so we'll have his name called loudly, distinctly 3 times. Deputy Everett, in just a moment, make sure I've got everybody. That would be Michael Edward Lobb, LOBB. Let's go ahead and call Stephanie Rios. Mr. Manning, I understand what you said earlier about she's giving information to the bondsman. And then Mr. Price just pled. So 20. We'll call Justin Hodges. I believe that's all that I have. You seen anybody else? Say again. He was here.
Your Honor, Michael Lobb just left me a voicemail message that he thought his court date was on December the 15th. I told him that I looked it up and it sent to him, and I gave him the address on 11/15, and it said if he was out of jail, he was to appear at home. So
Does the notice of appearance say today or does it say the 15th? Says today.
it was sent on November the 15th, but it said the date of court date is 12/1 at 1:30. But he was released from custody on the 23rd.
We'll let him call his attorney and his bondsman, and I'm sure they'll come together with a meeting of the minds on something. All right, so if you'll call those names. Yes, 1:30. Sorry. When you get that thing off. When you get that thing off. Well,
Mr. White is out here. He has a jury summons for the fifth and he wants to know if he can be relieved because he has to go to get a shot in his back.
I don't think the state wants to use a strike on him anyway, so.
I think no one would be very close thing. He's seen enough, he's like, oh yeah, no, I don't know.
All right, Stella, you ready? We're gonna call these real quick. All right, the court has called CR 2269 Michael Edward Lobb. Court has called CR 21309 Stephanie Rios. CR 22148 Justin Wayne Hodges. Those three individuals were not present in the courtroom when their names were called as scheduled at 9 a.m. They are not present at this time, which is 12:30 p.m. The names have been called loudly, distinctly 3 times in the courthouse with no response. Court hereby issues a judgment nisi and alias capias. That will conclude the morning dockets. Court will resume at 1:30 p.m. for the jail docket.